All right, thank you, everyone, for joining us. Welcome to the International Anti-Corruption Court, IACC Youth Talks series, an initiative led by the Youth Leaders Network of Integrity Initiatives International in collaboration with our partner, Youth Against Corruption. My name is Marjila Basij Rasekh, and I am the coordinator of the Youth Leaders Network. This session will be recording and is a public webinar. Today, we are privileged to have Justice Maria Wilson, Helen, Brady, Rebecca Shute, and later Judge Ivana Hrdličková will join us. Our session today marks a crucial dialogue on the tapestry of international courts, exploring themes such as the role of institutions like the Special Tribunal for Lebanon, the International Criminal Court, and the International Court of Justice, through reflections on past lessons and insight into the IACC's added value. We aim to deepen our understanding of global justice mechanisms and the fight against corruption. The IACC Youth Talks series serves as a rallying point for youth worldwide, fostering awareness, inspiring action, and uniting against corruption's corrosive impact on society. By amplifying youth voices and driving meaningful change, we collectively advocate for accountability, transparency, and ethical governance. Please note that we will be holding the IACC Youth Talks on the last Wednesday of each month. In May, we will conclude these talks and transition into a workshop where we will ideate the next steps, strategy, and action plan. Now, allow me to introduce our amazing moderator, Robert Okello. Robert is a social entrepreneur specializing in technology development and justice. As the Europe lead for Barefoot Law, a nonprofit organization, he provides free legal support to disadvantaged Ugandans using innovative approaches that blend technology with traditional community programs. With a focus on Africa-Europe digital cooperation, Robert works to foster locally driven innovation and strengthen governance. Previously, he contributed to policy research at European Center for Development Policy, focusing on Africa-Europe cooperation in governance, digital, and youth sector. His research interests lie in digital transitions with the justice sector, particularly in enhancing access to justice and legal empowerment for rural women. Robert holds a master's degree in development studies from the International Institute of Social Studies of Erasmus University, Rotterdam, a bachelor's of statistics from Makerere University, and a diploma in law from Law Development Center. Without any further ado, the floor is yours, Robert.
Thank you very much, Marjila, and good morning, good afternoon, good evening to everyone joining us from wherever you are. It's about 8 minutes past 3 p.m. here in The Hague, and I'm joining from The Hague Humanity Hub, and which is about 10 minutes from the International Court of Justice, and I think it's about 15 minutes from the International Criminal Court. Very interesting day we're having, and a very interesting group of experts that we have today in the field of international law, who will be dissecting the mandate and roles of international courts. So without wasting time, I'll just jump straight into it. We're starting with Justice Maria Wilson. Just a matter of introduction, Justice Maria Wilson serves as the Justice of Appeal of the Supreme Court of Trinidad and Tobago, a position she has held since 2020. She previously served as the Assistant Director of Public Prosecution and as a judge of the Supreme Court of Trinidad and Tobago. And at international level, she also served as a trial lawyer at the International Criminal Court in Tribunal Tribunal for Rwanda in Tanzania. So just to start the discussion here, Justice Maria, as a former prosecutor at the Office of the Director of Public Prosecution, I'm trying to understand how your background has sort of shaped your approach to international criminal law and procedure.
Good morning, everyone. Thank you, Robert, for that introduction. I am pleased and honored to participate in this panel discussion from Trinidad and Tobago. So to answer your question, every system of law has its own framework, and one has to study and become familiar with that particular framework and the jurisdiction of the particular court, their rules and procedures, their offenses, on the different statutes, definition of the offenses, as well as the defenses, definition of the offenses and the defenses available. But what I found were transferable skills for me, and which assisted me, is all the different roles in all the different roles I played, like as a defense attorney, assistant director of public prosecutions, trial lawyer, trial attorney, as well, and trial judge in the criminal jurisdiction, are as follows. I think, and sometimes people underestimate it, one has to be able to truly analyze the factual scenario that you're faced with, in-depth analysis. Because if one does that, one could quickly identify inconsistencies and contradictions and the issues which must be addressed. If this is properly done, then it could quickly lead you to what are the applicable laws that apply to the particular issue. And it's not that difficult to research what are the applicable laws. And I think that those are the transferable skills that they have assisted me in every position I've occupied, even now as a Court of Appeal judge. So I would say that, yes, in this answer your particular question, of course, as a trial judge and as a trial attorney, I appreciated the underlying offenses. I was very familiar with them. I prosecuted people for murder and all these sexual offenses. So when it came to the international criminal law, that knowledge was already there. It was simply to familiarize myself with their new framework and apply the way I analyze the law and the facts to enable me to bring that experience to that field of law. So it wasn't a difficult shift for me because of my past exposure and experience. Thank you for that question.
Very, very interesting. I'm just trying to build on that, what you've mentioned there, and also your experience within working within the judiciary. In your opinion, what role should the judiciary sort of play in promoting accountability and transparency, both from your experience at the domestic level and international context?
I think the judiciary plays a pivotal role in promoting accountability and transparency. Why do I say that? That's because people rely on the judiciary to uphold the rule of law. And if the rule of law is not upheld at a national level, that could lead to chaos. People take the laws into their own hands and they don't respect the court. So it's extremely critical for one to do that. And we no longer live in it's an island we live in, but it's really on an international scale. So whatever we do nationally will be viewed by international players as well. And therefore, and so our role is pivotal. And as an individual in the system, I have to play my part. For example, if I feel there are any conflicts of interest in the matter in which I'm dealing with, I must disclose that. Because at the end of the day, if people are aware of that, they don't trust the system anymore. And if foreigners who want to invest in the country do not believe that the rule of law is upheld, they'll be discouraged from investing. That will have an impact on the economy eventually. So to answer your question, we play a pivotal role because we uphold the rule of law in the way we address matters before us, in the way we interpret the law, and people rely on us to do our job efficiently and effectively. So thank you for that question.
Absolutely. I do agree with you with, with everything. And as a young activist, and within development space, we're often also questioning, what does justice look like? What is human rights in it? And I'm sure a lot of young people who are in attendance are also asking this question. So I was wondering, from your own, if you go to the field of practice now, as a trial lawyer and as someone who has been in the International Criminal Tribunal of Rwanda and
Yes.
International Court, how has it sort of shaped your general perspective on the question of justice and human rights?
Thank you for that question. I would say it has shaped my my interest in human rights and justice, but I have to admit, I entered the field of law because it sounds very lofty. I wanted to be the voice for the voiceless. I wanted to promote human rights for persons who couldn't do that on their own. So that was my reason for becoming a lawyer. I mean, my father was a lawyer too, but I don't like to admit that he had any effect on me. So that was my reason. And in every possible position, professional position I served in, I was able to use that to promote justice and human rights. So that's why, as a defense attorney, a state prosecutor, trial judge in the criminal arena, in every possible way, and even now as a Court of Appeal judge. So I think I've been fortunate to be in these different professional positions to use that position to actually promote human rights and justice.
Absolutely. And for the last question, I think you sort of tackled it a little bit on the second question which I raised, which is really the conversation that we're having today about the significance of creating an international anti-corruption court in the fight against corruption. How do you sort of perceive the significance of this body, the International Anti-Corruption Court, in a global fight against corruption, particularly, concerning the potential impact in fostering accountability and transparency?
Thank you for that question as well. I think it is absolutely critical that we establish an international anti-corruption court to address the issue of grand corruption, which is the abuse by public power for private gain by nations' leaders. Why do I say that? Because grand corruption has a negative impact on the ability of countries to meet the UN Sustainable Development Goals, to combat climate change, to promote democracy and human rights, and ultimately, of course, establishing international peace and security. Some might argue that there are other entities which already do that. They're regional bodies, and they too have as their aim targeting grand corruption. But the difficulty with just relying on those organizations, and I appreciate the fact that there's the UNCAC, UNCAC, and they're about 190 member states who have signed up on that. So they're laws that target corruption, grand corruption. However, the difficulty is the enforcement of those laws. And that's one of the critical reasons why we need a global court that addresses that issue. So yes, we are happy to have the regional bodies and other entities, but we need a global court because there's a gap in the international legal system that doesn't provide effectively for the enforcement of grand corruption. And why is that? Because at the local or even a regional level, we have leaders who are able to control the legal structure. They might do that directly or indirectly because they're the ones who are responsible for funding the police, the judiciary, all the entities within the legal system, legal structure, for in fact, enforcing enforcing the laws. So if there isn't financial support, that is an indirect way of preventing those bodies from doing what they have to do. So apart from that, there is the fact that the corruption is of an international nature. One has to, as you will appreciate. So we need cooperation between states. We need assistance with countries who don't have the resources to, in fact, assist them in fighting this grand corruption. And so we need to work together. We need an international body, in my view, to achieve that. And this body will in fact respect the sovereignty of such nations, because we intend to adopt the whole concept of complementarity. So it's only if nations are unwilling or unable to prosecute such grand corruptions that such a court will have jurisdiction over these crimes. So that I fully support an international anti-corruption court because of the nature of grand corruption. As I said, there's a lack of an international forum for enforcement of such of grand corruption. So those are my views on that. Thank you.
Thank you very much, Justice Maria Wilson. I think you've set the tone very, very well. And the framework exists, but the enforcement is still lacking.
Yes.
And I think also introducing in some, I'll get back to you just in a minute, introducing also someone who can also help us dissect this further is Helen Brady. Helen Brady is an Australian-trained lawyer. She's a senior appeal counsel and head of the appeals and prosecution legal coordination section in the office of the prosecutor at the ICC. In 2014, she has led prosecution on all appeals and post-appeal proceedings before the appeal chambers, advises prosecution teams, and coordinates legal positions in cases and situations. Also previously, she worked as the senior appeal counsel in the International Criminal Tribunal for former Yugoslavia. She also appeared for the prosecution in the appeals of 50 accused persons in war crimes and crimes against humanity and genocide cases in the ICTY and the International Criminal Tribunal for Rwanda. She has provided advisory on appeals and trials at different levels. She also served as the chief of the cabinet to the president of the Special Tribunal for Lebanon, Judge Antonio Casasas, formerly. She was also a prosecutor at the Office of Director of Public Prosecution in Sydney and worked in leading law firms in Sydney and San Francisco. She's also a member of the Australian government delegation. She was a member of the Australian government delegation to the negotiations for the ICC. And she was also one of the negotiators and drafters of the ICC statutes and rules of procedures and evidence. A graduate of UNU and Cambridge with LLM, honors first class, and she's written extensively at the International Criminal Law and Procedures. She's lectured at different international criminal justice conferences, and she's a trained judge and lawyer at various international and domestic courts. Very extensive experience, Helen Brady. The group we have today is a group of young people who are interested in international law, understanding justice, work in activism, enforcing corruption. But a lot of us, we clearly, even in The Hague here, so many citizens within The Hague, understanding the role and mandate of, the international courts and specific international criminal court is something that we still try to catch up with. And for me, my first question is, what is the primary role and mandate of the ICC, and sort of how does it contribute to global justice and accountability?
Well, firstly, thank you very much, Robert, for that introduction. And thanks to you and also Margila for inviting me to speak today at this conference on this panel. I should preface by saying that I work at the ICC, but I am here in a personal capacity today and my comments therefore will be given in my personal capacity rather than on behalf of the International Criminal Court. But to come to your question about what is the ICC, I think there'll be many in the audience. Maybe this is a very basic primer, but I thought it was useful to just set out exactly what ICC is and does, especially for those who may not be so familiar. The International Criminal Court is the first permanent court to investigate and prosecute war crimes, crimes against humanity, genocide, and it can also prosecute the crime of aggression. It was established by way of a treaty, which was agreed to by 120 countries in 1998. And after getting about 60 ratifications, the treaty entered into force, and then the ICC was able to open its doors and commence work from about 2003. So it's a criminal court, and it adjudicates or prosecutes and adjudicates individuals for alleged criminal conduct. There are 4 specific crimes in the mandate of the court, that is genocide, crimes against humanity, war crimes, and the crime of aggression. And there are many different forms that these crimes can take. So there are enumerated crimes within those broad categories of crime. At this point, we have 124 states who've joined the court by ratifying it. And those courts then provide the funding for the court, elect the judges, elect the prosecutor and the deputy prosecutors, and basically oversee the way the court's going to be managed. I think one of probably the most important principle, the cornerstone really of the ICC statute or the ICC treaty, the Rome Statute, is the principle of complementarity. And what that means is that the ICC complements national systems of justice. So it doesn't replace them. It, I guess you can think of the ICC as a court of last resort, because it can only step in when a state is unable or unwilling to investigate and prosecute crimes genuinely at the national level. Now, in terms of how situations come to the ICC, they can be referred in basically one of 3 ways. A state party can refer a situation, the UN Security Council, or the prosecutor, him or herself, at the moment himself, because prosecutor is Karim Khan. The prosecutor can decide to open an investigation proprio motu, that is on his own initiative. That if he does that, then he needs the authorization of the pretrial judge, the pretrial chamber, to do so. And there are some it's quite complex, but there are certain key criteria needed in order to open an investigation into a situation. Firstly, crimes have been committed since 1st of July 2002. For the crime of aggression, there's a different date. It's 17 July 2018, which was the date of entry into force for those amendments. Then the crimes have to have taken place on the territory of a state party or a state which has accepted jurisdiction, having made a certain declaration of doing so, or the crimes were committed by a national of a state party. But those are not required if that condition is not required. There's a Security Council referral. In that case, there's worldwide jurisdiction. The crimes have to fall obviously within the subject matter jurisdiction, which I've mentioned, and not have been or not being or have been investigated or prosecuted nationally, and also meeting a certain criteria threshold of gravity. Another key aspect of the statute is that state parties must cooperate fully. They're obliged to cooperate fully with the court in investigations and prosecutions. We have no police force, as it were, of our own, and so we rely heavily on state cooperation, support from authorities, from state parties, and also non-state parties. So this will be for all kinds of cooperation, as well as ensuring execution of arrest warrants. So briefly, we're currently conducting active investigations, or we have open investigations in 12 situation countries. That is the DRC, Darfur, Sudan, Libya, Cote d'Ivoire, Mali, Burundi, Bangladesh, Myanmar, Afghanistan, Palestine, Ukraine, Philippines, and Venezuela. And we also have, we've had a number of situations now that are what's called closed, but for which we still have outstanding arrest warrants and or conducting trials at the moment at the court. So we presently have ongoing trials in relation to an accused who is alleged to have committed crimes in Darfur. We have two trials going on in relation to crimes that allegedly occurred in Central African Republic, and in the Al Hassan case in Mali situation, we're presently at the end of the trial and awaiting judgment. So you've asked how it contributes to global justice and accountability. I think that the main thing we have to remember about the ICC is that it's not operating in some kind of isolated vacuum. It's not an isolated island of justice, international criminal justice. Of course, for the cases that, the situations in cases that the ICC itself is investigating and prosecuting, these will be very important for accountability in and of themselves. So those cases, especially as the focus of our cases is most often on the persons that are deemed to be the most responsible or have a certain degree of responsibility for the crimes alleged to have been to have occurred in the situation. And also because we focus on very, very grave crimes in any situation. Gravity is something which is mandated in the Rome Statute. And we also aim to try and represent as much as we can the extent of criminality which has allegedly occurred in a given situation. So the main types of victimization and communities affected. And we pay particular attention to what might be called traditionally or in the past under-prosecuted crimes such as sexual and gender-based crimes and crimes against children. So that's what we can do from our own cases and work in terms of contributing to global justice and accountability. But I would say that the Rome Statute system goes much wider than that. And it comes back to what I said at the beginning, that the ICC exists, it operates as part of a much wider, I've called it in the past archipelago, of international criminal justice actors on the international, on the regional, and on the state level. And at the core of this, of course, we have complementarity. So equally important to the work that we're doing, and we have certain constraints because we have certain resources and financial restraints, but beyond what we're doing, the really important contribution of International Criminal Court is the dynamic relationship that we have with states who themselves continue to have the primary responsibility to investigate and prosecute these crimes. So, and I think this has become more and more important or obvious as the years have gone on since I've been involved in this area, that really the ICC is a hub. It's described as a hub for international accountability, with cooperation then going both ways. ICC will assist states and the efforts that they have to investigate and prosecute these atrocity crimes, and vice versa. So, you know, there's a burden sharing of these crimes, because the ICC cannot do it on its own, essentially. And I think the goals that the ICC has to try and combat impunity and to prevent recurrence of violence really requires and is best achieved by combining the activities of the court in The Hague, or wherever else it may sit, if it sits elsewhere, and those of national systems. Thank you.
Yeah, thank you very much, Helen. I think it provides a very clear sort of snapshot of what the ICC does. And I was wondering particularly on some of the crimes that or the cases that you've handled. What is the intersection between corruption and other forms of international crime, and what role do you think the IACC, or the International Anti-Corruption Court, could play in addressing this nexus?
Thank you for that question. That's extremely interesting. There's an obvious intersection between atrocity crimes that we deal with at the ICC and grand corruption. The crimes can really be seen as almost feeding off each other. Corruption can often fuel the atrocity crimes, and the atrocity crimes in turn then pave the way to more corruption. So in a sense, it can then breed this cycle of criminality. And I think that the one thing I've learned, or not the one thing, but one of the things, hopefully I've learned more than one in my years, but one of the things over the past 20 years or more, actually, prosecuting international criminal cases, I see the motivation or the reason behind often, not always, but often, these atrocity crimes, war crimes, crimes against humanity, is to acquire, territory, natural resources, money, etc. And then it's then linked to corruption and kleptocracy of certain groups within the state, often very elite groups. And the groups then, what they're doing is they can often take advantage of weak institutions in the country, which are themselves the product of corruption, and then take advantage of the ongoing armed conflict and the situation of the widespread and systematic attack against the civilian population to fuel more corruption. And many suspects, not all, but many, will be or are significantly enriched after the crimes have taken place. So it's often, I think, the reason for the crimes in the first place. And having a corrupt state or society in which certain players can operate sort of creates the opportunity that they may need. Now, obviously, at the ICC, we investigate and prosecute crimes after they've occurred. I mean, that's not to say we cannot be in an ongoing conflict and prosecute crimes as they occur. But in terms of the actual investigation of a crime will occur after it's happened. but obviously preventing crimes from occurring from the start would be preferable. And I think that an international anti-corruption court, a permanent one, if it was established, similar to the ICC, could contribute in that way to preventing the types of crimes and the serious harms that come before the international courts and tribunals.
Thank you. I think a follow-up question from that is that also one of the things that came up in your background work is that you've been involved in drafting and writing some of those legal statutes, both for ICC and some other courts. In your opinion, what are some of the critical components do you think this court, the anti-corruption courts, should have to ensure its effectiveness and legitimacy?
Yeah, that's a really big question, and obviously it's one at the moment which is presently ongoing and occupying the minds of various people and various committees in the IACC drafting and treaty committees, which is being coordinated by Integrity Initiatives International. I see Ian Lynch is also here today. And I don't profess to have all the answers because it is such a huge topic. But I think at a minimum, you do need to see certain features in the treaty. Firstly, I mean, among them, in no particular order, but the principle of complementarity and how that's going to look, how that's going to work or operate in practice vis-a-vis states. There's provisions on this in the ICC statute. That can be a start. What is the jurisdiction of the court in terms of its core crimes? A decision has to be made about that. Are they the crimes in the UN Convention Against Corruption? Are we going to include other crimes? What is going to be the territorial jurisdiction of the court? The treaty or statute should really need strong provisions on cooperation in all its forms in terms of arrests, but all forms of cooperation with the court. And it can be written in a way that deals both with state parties as well as even non-state parties. I mean, it might be a different form of obligation you can put on a non-state party, but you can actually allow a non-state party to cooperate. The statute or the treaty will also need strong provisions on how immunities will work, insofar as they ensure that they don't protect present or former officials from prosecution by the court. That'll be important because of by the nature of the crimes and the nature of potential defendants who may come before the court. It needs to have provisions on what is the applicable law, how does that work, like in the Rome Statute, what do you look at to find the law? Powers to seize and freeze and control assets which have been reasonably suspected of being illegally obtained or laundered. I think a strong section or part provision is needed on the composition of the court, ensuring that, as Justice Wilson said, ensuring that there is a strong, independent judiciary. That's key. And independent office of the prosecutor, a properly resourced and staffed registry, and potentially other sections or units, etc. A supervisory body, clearly, for the overall management. So similar, the same, but as the Assembly of States Party. Provisions setting out powers of the prosecutor and indeed the court and how it operates in relation to investigations, the investigation phase. Provisions on witness protection. I know that whistleblower protection would be important in this area, and provisions on all the aspects of running a criminal court. It doesn't have to be super, super detailed, but the basics on how does the trial run, what are the powers of the trial chamber, what's sentencing, what factors, etc., and appeals. So, as I said, the basics need to be there. With further detail, it can be elaborated in the Rome Statute. I also think it's important to have a section on offences against the administration of justice to stop people who may be tempted to try and thwart the work of the court by potentially approaching witnesses or other people and doing things that mean that the court cannot receive evidence in a proper way. So generally, I think the key, and it's very much ongoing at the moment, but the key is to draft a treaty or a statute which covers all the key areas, but not getting overly bogged down in detail, which might be better off reserved for the rules of procedure and evidence and other regulations of the court and, you know, the registry regulations. I mean, these courts, once they operate, tend to also, you know, develop a life of their own, and state parties to join need to see the basic blueprint, and that should be in the treaty. And some of the details on specific procedures, I think, can be reserved for other regulatory documents.
Thank you very much. I think, as you mentioned, I think you can go on and on on the provisions that are needed for the court. But I think in the beginning you mentioned one of the key roles, or some of the roles that the ICC also plays, is advancing gender equality. If there are examples, what do you think are some of the roles that ICC play in sort of advancing gender equality and also women's rights, particularly in the context of its mandate, but also cases it has handled, and if there are any lessons that you think the anti-corruption court can also borrow in this aspect?
Yeah, again, it's a big question, it's a broad question, but I think the ICC has played an important role in several different ways on that topic. Firstly, in terms of the crimes that we prosecute, the Rome Statute sets out the widest range of sexual and gender-based crimes that was set out in the similar statutes or constitutive documents of the other international courts and tribunals. So we have jurisdiction over rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, and what's called any other form of sexual violence of comparable gravity, as war crimes and crimes against humanity. And we can also prosecute persecution as a crime against humanity, and one of the grounds of that is based on gender. We have several cases in which sexual and gender-based crimes against both women and men have been charged. Just to name a few, we have convictions for these crimes in the Ongwen case recently from Uganda, the Entaganda case. We've got a couple of cases pending in trial, Al Hassan from the Mali situation, Al Rahman case, which is presently in trial. So that's sort of, just by the way of the crimes. But I think a second very important way that we can, or the ICC can contribute, is by playing what might be called a normative role or standard setting. And so, for example, the ICC recently published a policy on gender persecution, as well as a updated, revised policy on gender-based crimes. And those policy documents not only guide our work, but those policies, together with the important jurisprudence which is coming out from the court, can in turn be used by national states in its investigations and prosecutions of such crimes. Under those policies as well, and we do it as a matter of practice, we're mandated to take a gender-sensitive approach at all stages of our investigation through to trial, sentencing, appeal. And that has been progressively advancing and evolving over the past, since its inception. And so that's another really important way that we can contribute to the crimes. But in another sense, the ICC can advance, I mean, I think your question was more about gender equality and women's rights through its institutional framework itself. And the Rome Statute actually has a number of provisions or components which are aimed at promoting gender equality and women's rights. For example, in the selection of judges. I think some people might not think it could go, some people might think it could even go further. Don't forget, this treaty was drafted in 1998, but it does provide that in selecting judges, state parties should take into account the need for what they call a fair representation of female and male judges. Also, judges, it's mandated in the statute that they have to have legal expertise on specific issues, including violence against women and violence against children. And similarly, for the Office of the Prosecutor, there's a provision in there that basically says that the prosecutor shall appoint advisors with legal expertise on issues, including, not limited, but including on sexual and gender violence and violence against children. And in the OTP, we have, in the Office of the Prosecutor, sorry to use the acronym, we have a whole separate unit, the Gender and Children's Unit, who works with all of the teams, all of the investigative teams, prosecution teams in the office. So these are just some of the ways that, you know, the ICC can try and achieve those goals. And in terms of lessons for an international anti-corruption court, I was thinking about this earlier, how that would affect or work with the IACC. I think that even though the crimes being prosecuted, investigated by an IACC will be different, clearly different from those at the ICC, because now we're talking about corruption crimes, I think it's still going to be necessary and important to consider the gendered aspect of those crimes in all phases of the case. So that's because corruption cases or crimes will no doubt impact men and women in society in different ways. So that's something that will probably have to be taken into account in investigating and prosecuting them. I also leave that to others who have more experience than I do in prosecuting those types of crimes and how they may affect men and women differently. And I think also when the IACC is designed, gets set up, it can also draw upon and indeed, I think even strengthen now some of those institutional structures and framework of the ICC insofar as promoting gender equality, diversity, and inclusion.
Thank you. Interesting that you mentioned one of the cases, Dominic Ongwen case. I'm from northern Uganda, and as a young boy, I experienced firsthand the LRA, and I saw the violence that happened at the time. And I was also privileged to be in one of the court sessions here at the ICC and listen to some of the evidence which were being presented in Luo local language.
Oh, wow.
And very, very interesting. the work of the ICC. I'll come back, to dissect this more, but I wanted to jump onto Rebecca Shoot to sort of bring in perspective of sort of community or citizen mobilization, civil society participation in this process of international court coalition. Rebecca Shoot is the Executive Director of Citizens for Global Solutions. She previously worked as the Technical Advisor for Global Programs at the American Bar Association, Rule of Law Initiative, and convener for Washington Working Group for the International Criminal Court. She also previously worked at Parliamentarians for Global Action as Senior Advisor for Democratic Renewal and Human Rights and Director of the International Law and Human Rights Program. She held various positions also at the National Democratic Institute. Thank you for joining us, Rebecca. To bring in the citizens' perspective.
Robert, I think we've been joined by Judge Hrdličková, and I think the agreement was that when she was able to join us, perhaps we could take an interregnum. So thank you for the lovely introduction, and I'm happy to pick up my comments after the judge.
Thank you, Judge Ivana, for joining us.
Good afternoon, and thank you very much for the time and understanding. Thank you.
Thank you for your time, for joining us. I'll just make a quick introduction. Judge Ivana Hrdličková, she's a Czech national. She began her career as a judge in 1990 and has been presiding over both civil and criminal cases. She holds a PhD in international law with a focus on the relationship between international and Islamic law. From the law faculty of Charles University in Prague, she specialized in the development of rule of law in post-revolution societies and has extensive experience working with transnational judiciaries, human rights, women's rights in various countries. She's also a member of international teams that train judges and lawyers in international public law, international criminal law, rule of law, and independence of judiciary. She was appointed judge of Appeals Chamber of the Special Tribunal for Lebanon in 2012. She was elected as the president for the Special Tribunal for Lebanon in February 2015, and she served as the president since 1st March 2015. Thank you for joining us. And I'll jump straight forward to the question. Why is it important to create a special tribunal specifically for Lebanon, and what was its role in the broader context of international courts?
Thank you very much for your question. I'm delighted for the opportunity to share with you some experience. A special tribunal for Lebanon was created under very special circumstances as a reaction, immediate reaction of assassination of former Lebanese Prime Minister Rafik Hariri. And that time, it was important message from international community that there is no impunity and should be no impunity for horrendous international crime, including terrorism. And it was the first time ever when victims of terrorism could have been heard, they could have shared their stories with judges and to get justice. The circumstances of establishment of the tribunal were also very specific because in the beginning, there was agreement negotiated between Lebanese government and United Nations. However, due to political changes, the agreement could not have been ratified. Therefore, Lebanese government requested United Nations to step in, and then Security Council issued a resolution according Chapter 7, saying that there was a threat of international peace and justice, and the tribunal was established. And I believe in international justice, international criminal justice, and although it can never, ever replace or substitute national judiciary, this is always the most important. I think it is the second important tool to preserve and build international peace and security.
Thank you. I was also wondering, because a lot of these courts, of course, are continuing with handling different cases, prosecuting different cases. But what are some of the challenges do international courts and special tribunals face in investigating and prosecuting cases? And do you sort of foresee international anti-corruption court investigations as being more or less difficult compared to the tribunals and the international courts that exist?
There are many challenges, financial and everything, but I think if I have to name one, it's cooperation, because no international tribunal at all can function well without cooperation. And for International Anti-Corruption Court, the cooperation certainly will be also important. If the tribunal has secured cooperation with the states the tribunal needs, then can function well, and then all other measures can be implemented. But without cooperation, and we could have seen that, first is that even establishment, functioning, financial, but if there is support for establishment, it still does not mean that the cooperation continues. Sometimes there are objective reasons why the cooperation is more difficult or not, but I think the cooperation is absolutely essential. It is the key. And all good functioning of tribunals depends on cooperation.
Thank
State
you.
cooperation, and I mean, and a cooperation, I mean, judicial, which is the first, but also diplomatic support, financial, of course, is very important.
Thank you. Also, I was wondering, with your expertise in the relationship between international law and Islamic law, how did the Special Tribunal for Lebanon navigate the intersection of this legal framework in its proceeding and judgment? Any lessons for the creation of anti-corruption court?
Thank you. The Special Tribunal for Lebanon applied national substantive law, criminal law of Lebanon, while the procedure law was purely international with some domestic components as well. And Lebanese criminal system is not based on Islamic law. However, knowledge of that system helps to understand the circumstances, the barriers, also the culture. And I think this is important, whatever legal system the tribunal is dealing with, even if it is not applicable law, it is always important and beneficial to understand the accused, to understand the victims, but also to understand the society. Because one of the reasons, I believe, of international criminal justice is, of course, to help those who are responsible for crimes, but also to bring justice to victims and reconciliation in society. So it is important.
Thank you. I think a final question before I sort of go to the next is that how did the Special Tribunal for Lebanon engage with local communities and stakeholders in Lebanon to ensure that its work is understood and supported by population, especially given the sensitive nature of the case it was handling? And maybe are there lessons that the anti-corruption court can pick up?
I believe it is essential to engage with the local societies, with civil society, and especially if the court or tribunal is held outside of the country, then it is even more important to bring it closer to the local society. So with the STL, we closely worked with the Bar Association, when we could also with the judiciary and civil societies. Then we established also inter-university training program for young, not only young, but mostly young people, online teaching them international criminal law, which very popular also, not only international criminal law, but the tribunal itself. So I think it is essential for credibility, but also for awareness of tribunal and justice, international justice generally. So I believe for International Anti-Corruption Criminal Court, it will be important as well, and to have probably a communication strategy since the beginning, and then to have to be consistent, but also to have to be flexible, to adapt and to deal with different part of societies. I think that's crucial.
Thank you very much. I think very clear. If you have any question, I think now would be the time to post it on the chat, or you can use the button, raise your hands if you have questions, especially for Judge Ivana, who's only here for 30 minutes with us. So feel free to ask any question from the discussion, from what you've had since we started until now. Thank you very much, Judge Ivana. I wanted to bring in the perspective quickly for the citizens' mobilization for international court. Jumping back to you, Rebecca, how does your advocacy work at the Citizens for Global Solutions link to the work of international courts? And why is it important for citizens, governments to support the work of international courts?
Thank you so much, Robert. And it ended up being a very fitting segue, I think, from Judge Hrdličková. Excuse me, Judge, for mispronouncing your name so terribly. So I would like to start out by just thanking the organizers and saying how delighted Citizens for Global Solutions is to be a part of the campaign for an international anti-corruption court, and commending the wonderful work of Integrity Initiatives International and our friends Ian and Sarah, as well as the Youth Leaders Network. Citizens for Global Solutions is a non-governmental, nonpartisan organization that for more than 75 years has supported the rule of law. And so this is very much in keeping with our ethos, our history, and our current day priorities. Our organizational background includes being a foundational member of the Coalition for the International Criminal Court. And I don't think it's hyperbolic to say that without the CICC, the court would probably not exist, and certainly would not exist in the form that it is today. And I look at Helen and see if she's going to make any expressions there, if I'm speaking out of turn. But the CICC started as 25 members in 1995, and it's grown to the world's largest international justice coalition with well over 1,000 today. What I think is critical to recognize about the CICC as we look to it as a potential model for galvanizing civil society around an international anti-corruption court or other international justice institutions is that it continues to play a pivotal role. Every year, the CICC helps convene the Assembly of States Parties, and at the NGO roundtables that are upcoming in June this year, helps convene a series of side events and a series of deep conversations on various aspects of the court's functioning. Currently, the coalition is doing critical work around complementarity and cooperation. Tomorrow, there will be a conversation with Helen's office, with the OTP, on their ongoing strategy on complementarity and cooperation. We do similar work on selection of judges and vetting of judges. The ICC election process is very complex and still evolving, as are numerous procedures of the court. Now, today, my organization also applies the same logic and the same organizational campaigning style to work in support of the universality of the International Court of Justice. We have a campaign that I think my colleague Drea can put in the chat called Legal Alternatives to War, to support states accepting compulsory jurisdiction of the ICJ. And I think we'll get into the weeds on this a little bit later. These are very complementary initiatives, as is the drive for an international anti-corruption court. Now, why does it matter that citizens support and government support? To get back to the thrust, I think, of your question. Well, it's imperative that governments support these institutions because without universality, or at least a high degree of acceptance among states of their jurisdiction, the promise of accountability is illusory. And even when you have states, I'm coming to you from Washington, D.C., by the way, in the United States of America, that are persistent objectors, the United States not being a member of the Rome Statute of the ICC, not having accepted compulsory jurisdiction of the ICJ, there's still a very important role for those non-states parties to play in terms of cooperation. And as has been mentioned, I think by Justice Wilson and Ms. Brady, in terms of enforcement, given that none of these organs have their own enforcement mechanism, as would be seen by an IACC as well. At the same time, we do push at my organization and in our coalitions for a universal ratification of the Rome Statute, and would do the same for the IACC and do the same for compulsory jurisdiction of the ICJ. And another link that I'll try to put into the chat is a recent opinion piece written by one of our National Advisory Council members, Ambassador David Sheffer, who is the first ambassador at large for war crimes, now styled global criminal justice, who inked his name, who signed the Rome Statute on behalf of the United States. And it calls for the United States to ratify the Rome Statute. Wearing another hat, I'm the co-convener of the Washington Working Group for the ICC, and I assumed that role the day after the previous administration, the Trump administration, announced sanctions on the then prosecutor and one member of the registry. And so civil society has been integral in good times, bad, and certainly ugly times in supporting international justice. So I think I will pause there, and I think we can move on with the conversation. And I really want to delve a little bit more into the nitty-gritty of the ICJ in particular.
Yeah, thank you, Rebecca. I would also be interested to understand what strategies the Citizens for Global Solutions sort of employ to mobilize public support. You talked about building coalition with civil society and government. How do you sort of mobilize the supports?
So I look at our advocacy as building smart coalitions in basically 3 concentric circles. So you have greater public awareness of these institutions, what role they play for humanity and what role they play for the rights of an individual. They can seem very remote, especially when you're talking about an ICJ or an ICC over in The Hague. Judge also spoke to the perception of justice as being removed if there is a special tribunal that is not in the states that are critically affected. So public awareness is key, of course, to put political pressure on elected officials, but it is also key for the cause of international justice as a cause for all humanity, as Kofi Annan said of the ICC's foundation, that it was the cause of all humanity. So we mobilize greater public awareness at my organization through direct outreach. We're a membership-based organization, and we at the grassroots level try to connect. I'm the U.S. member organization. We are the U.S. member organization of a global movement called the World Federalist Movement. So I try to mobilize in my constituency, my jurisdiction, the United States, to have folks more aware of these institutions, and also to dispel persistent myths and in some cases, kind of rampant disinformation and misinformation. The next concentric circle, getting a little bit closer, are affinity groups, civil society organizations, and critically, as I think Judge mentioned, bar associations, legal entities, academic institutions that are in a position not only to further the acceptance of these courts and tribunals, but to better them. And continue to improve and enhance them, because even the most well-established, we were talking about the ICJ, which has been in existence since 1945, or even further if you look at its predecessors, but is still a work in progress. And that's why we really need legal community. We need the young people that are on this call that are interested in activism, that are interested in in the cause of justice to be involved. Okay, and then the smallest of these concentric circles, or getting close to the nexus, is of course advocacy with states. And here as well, a lot of our work is dispelling myths and persistent bugaboos, complementarity being a huge one. The basis for jurisdiction of any of these courts is when there is an unwillingness or inability to prosecute domestically. An underused argument that I see, for example, for ratification of the Rome Statute here at home in the United States, is that it betrays a fundamental lack of faith in our domestic judicial system if you are unwilling to accede to the Rome Statute. That you're saying that we do not have an evolved enough judicial system, or do not have the political will to go after individuals who are alleged to be responsible for the most heinous crimes contemplated by humanity, the atrocity crimes under the Rome Statute's jurisdiction. There are also capacity concerns when it comes to states' accession to these courts, or acceptance in the case of the ICJ of compulsory jurisdiction, that can be dispelled. There obviously are limited resources for small and developing states, and where to place those is of paramount importance to them. And here is a way that civil society can help a great deal. And this is one of the objectives of our Legal Alternatives to War campaign, to provide that support to states that otherwise might not be able to avail themselves of justice in the same way as the power players. And I will, I guess, just end on this question with the fact that states, I think it was mentioned before by Ms. Brady, that a governing body is essential to any international judicial institution, as it has been to the ICJ and the ICC. And states have those seats at the table. Civil society can be in the gallery, and civil society needs to be in the gallery and not shut the door on. And as we look to the creation of an IACC, I would advocate very strongly for a continued role for civil society, as we've seen with the ICC, for instance.
Thank you. And looking, I think you've mentioned it a little bit on some of the things that you're working on at the Citizens for Global Solutions. Looking ahead, what are some of the key priorities and goals for Citizens for Global Solutions in its effort to strengthen international justice mechanism? You touched on it a little bit, but I just wanted you to.
Support for the International Criminal Court remains a bedrock existential goal and objective of Citizens for Global Solutions. And we do this today through very active engagement with the Coalition for the International Court, and also advocacy domestically in the United States, not only for ratification of the Rome Statute, but other means of complementarity. However, I'd like to switch over to our work on the International Court of Justice, as this is a newer campaign. It was launched in October of last year. And actually at our launch event, we had two then permanent representatives to the United Nations who were subsequently, just 10 days later, elected to be judges of the court. And what the ICJ campaign, called Legal Alternatives to War, seeks to advance is universal jurisdiction of the ICJ. Now, the International Court of Justice, as opposed to the International Criminal Court or the other tribunals of which we've spoken, hears disputes between and among states. And we heard from Ms. Brady how situations and cases reach the ICC. Cases reach the ICJ in one of four ways. One, a request for an advisory opinion. And I think we'll talk about a current advisory opinion request by the UN General Assembly. Two, because in the bounds of a treaty, the ICJ has been decided upon as the mechanism by which the treaty will be resolved. Three, if there is an acceptance of special jurisdiction by states who are in a dispute. and 4, by acceptance by states of compulsory jurisdiction over all contentious disputes. Thus far, only 74 states have accepted the latter, compulsory jurisdiction over contentious disputes. And so that means that a large swath of potential injustices in the world, potential disputes in the world, are not given the means or do not have a mechanism for resolution. So this is a huge priority of my organization right now, working towards greater acceptance. We have the goal of universality by the centennial anniversary of the court. Maybe we'll get to universality, but we certainly think that we can get a whole lot further in advancing states' acceptance of the court, and also better use of the advisory opinion mechanism. I'm going to, I think, later in our dialogue, give some examples of why the advisory opinion option can be so profound and can have so much effect, not only for states, but for individuals.
Thank you. And then finally, drawing from your background in the promoting democratic renewal and human rights, I'm just bringing it back to the discussion we're having in anti-corruption court. What are the mechanisms and approaches do you think are crucial for ensuring accountability and transparency within the International Anti-Corruption Court? And how can this mechanism be effectively integrated in designs and operation?
Well, I want to start, I think, about why an IACC is absolutely necessary and the lacunae or the gaps that exist in the current international legal framework, referred to as a tapestry, I think, in the title of this this chat, and then Ms. Brady as archipelago, ecosystem, choose your metaphor. But the point is that these are a very complex and interrelated set of institutions. So the ICJ hears disputes between states. The ICC has jurisdiction over individual criminal responsibility for 4 specific crimes. There are regional institutions, as Justice Wilson alluded to, that have some jurisdiction over corruption. And of course, there is domestic jurisdiction over corruption crimes. But this leaves a lot of stuff out. And I think Justice Wilson made a very convincing case at the outset. It was the perfect way to begin this conversation of why we need an international body to deal with this fundamentally an international concern, which is grand corruption. And here I'm going to take this back to your question, the thrust of your question, which is what can you learn from democratic development? Grand corruption, I think, needs to be separated and needs to be understood as a distinct crime with specific elements, the same way that the Rome Statute articulated the 4 crimes under its jurisdiction. And that work has been ongoing. And it has been the great work of the folks at Integrity Initiatives International, inter alia, to make this very specific. Why is that important, and why do I relate this to democratic development? Is because corruption can be seen as a construct of a global north or a global west, or of certain power makers, of certain agents, and that is not the case. There needs to be I think, and this is why these conversations are so important, a concerted effort to bring along civil society, to bring along youth, as we're doing here, and concerned agents and stakeholders across the globe to understand why an international anti-corruption court is so important to them and for them. And we can imagine, I'm not sure if we're going to have time to get to our last question, so I'm going to jump to it. We can imagine one set of concerns or one set of challenges being dealt with in different ways by each of these institutions. So I'll take, for example, the ongoing climate case before the International Court of Justice. This is an advisory opinion that was requested unanimously by the UN General Assembly to determine what the responsibility of states are, what the obligations of states are with regards to climate change. And so this is going to be completely novel that the ICJ will be rendering an opinion that will have vast ramifications for every state with regards to its domestic policy as well as its interstate relations. At the same time, there are complementary proceedings before the International Tribunal for the Law of the Sea, ITLOS, regional bodies, domestic bodies, and one could foresee an international anti-corruption court being called of the question of what is the role of corporations, what is the role of international financial institutions with regards to environmental crimes. The prosecutor of the ICC has indicated that he sees environmental crimes currently within the purview of the Rome Statute, within war crimes and crimes against humanity. They are within crimes against humanity clearly articulated. There is also a call, and there has been an independent body asked to look at the question of whether ecocide should be a further crime within the Rome Statute. So you can have all of these threads in the tapestry knitted together to help achieve a vision of justice, not only for humanity, but in this case, for our planet itself.
Thank you very much, Rebecca. I think you brought it out clearly, the role that civil society and citizens play in the creation and support of these international courts. We have, I think, a comment from Gesa, which also links to what Rebecca has been talking about. Gesa Mike Munabi, he's a student for Global Democracy Uganda, made a very good comment that we are members of coalition of the International Criminal Court. And I think in the past years, he has been in the mobilization with different young people. They've done projects on popularizing the role of ICC among student community. He has also re-echoed that it's important to promote, to engage civil society in the promotion while promoting role and legitimacy of international anti-corruption court among ordinary citizens in all countries. So thank you very much, Gesa, for your comment. And just before Judge Ivana leaves us, jumping back to our last final questions for you is that what measures did the Special Tribunal for Lebanon take to uphold the independence and impartiality of its judges and staff, particularly in the face of external pressures and political interferences? Are there lessons that International Anti-Corruption Court can take from this?
Thank you. Yeah, it's indeed important. We adopted unanimously, all judges in 2016, Code of Conduct and Ethics for Judges. And also we work together with judges and Nuremberg Academy with judges from other tribunals. And last year was adopted a code called Ethica, International Judges Guidance, like interpretation of that code of ethic and ethical principles. And it is not that judges don't know how to behave, of course, that's expected. But there were some nuances, and I think also what was important, creating this group across other tribunals and judges to have forum for discussion, because sometimes if some judges feel pressure, it might be difficult to deal with that. So to have written guidance agreed upon everyone, plus to have common, to have this platform to discuss all the possibilities, support each other, that enhanced independence, impartiality, but also like self-awareness about what could potentially be seen as problematic. And I think this practice for all the judges, staff, but also other stakeholders, prosecutor and everyone, is important, not only for internally the court, but also for public to be seen that judges and other, of course, officials are serious about the independence and professionality.
Thank you very much, Judge Ivana. And lastly, before you leave, is what do you see as the future role and potential of International Anti-Corruption Court in combating grand corruption and promoting good governance globally?
Yes, I said I truly believe in international criminal justice, and I'm hoping that the court will get support for state support and cooperation. And with all the initiative, I think it's possible, but at the same time, it is crucial. I think it is excellent that young people are already engaged in the campaign, because the young lawyers and other young professionals are the future. And I think they are very powerful. So I think the more they will be engaged in campaign, I would also believe that the more the states will listen to them.
Thank you very much, Judge Ivana. I don't see any question particularly directed to you.
Thank you very much. So if you allow me, I will leave, and thank you for understanding. Wish you all the best and many grateful thanks for inviting me. Thank you very much.
Thank you. Thank you.
Thank you. Bye-bye.
Thank you. Just continuing with from where Judge Ivana stopped. This is a question that I sort of wanted everyone to, you can address it as you wish, which is that as someone with, of course, extensive experience in, oh, my question is a bit jumping all over the place, but so the question is around the role of young people. We have a lot of young people who are attending the session today, and what message do you have for them, in those who are interested in activism in international courts, but also supporting the work of international courts? What are the sort of the steps that they should sort of adopt or they can use to participate, but also to get involved in the court processes, just from your own experience, but also from your own background in growing and developing within the legal field, for the different young actors that have joined us today. And I would I'll throw the question to Judge Wilson first.
Thank you, Robert. I think it is critical for young persons to, in fact, get involved. And one of the ways they can do that, and I'm focusing now on the International Anti-Corruption Court, the proposed court, they could become involved in civil society and form with a body that's in existence, or create a group of persons to promote support for that court. I also think III, they can provide them with different ways in which they can participate in the campaign for this court. But it is important that young people's voices are heard, because they're the ones who are passionate and they have the energy and drive to stay the course and to make this happen, because this court will not happen overnight, but that should not prevent us from gathering support as many countries as possible to make it a reality. And I think all of us who are here, we're here because we are passionate about that vision, and we want to find ways to make it a reality within our lifetimes. So that's my response. Thank you.
Thank you. Helen, do you have any submission in this question?
Well, it's hard to beat that, because that's very well said. I mean, clearly the future in all these areas of international justice, whether you're talking about the International Criminal Court or the IACC, future IACC, is with young people. I mean, I've been very lucky. I've had a substantial part of my career sort of in this area of international criminal justice from a relatively, young age until my ripe old age now, which I won't reveal. But Rebecca mentioned the momentum for the ICC. and the important role played by the Coalition for the International Criminal Court. That was key. I actually, the first time I ever went to a meeting for negotiating the Rome Statute was in 1997, and it was as a member of, I was in a human rights organization in Australia, and I went as a member of that organization, representing that organization as part of the coalition for the CICC to those negotiations. And I just remember it was like a life-changing moment, because I looked out and I was like, oh my God, wow, this is amazing. This court could actually be created. Now, this was in one of the, what did they call it? The preparatory committee meetings in the United Nations. So before the diplomatic conference, etc. Then I was really fortunate to be selected on my government's delegation. And I spent 3 years alongside my normal job as a prosecutor. But from 1998 to 2001, probably had one of the best professional experiences of my life by being able to participate as one of the delegates for a government, my own from my own country, in the discussions to create the International Criminal Court. So to draft the statute, to draft the rules of procedure, and the other elements of crimes. And yeah, sometimes you don't believe, but that one person can make a difference to how a provision actually ends up looking like. And so it's really, in some ways, it all comes down to the individual. So if the IACC momentum, and it reminds me, when we went to, it was part of a group, Justice Wilson's in the same group, being put together by III, Integrity International Initiatives. I always forget the entire name, but III, that's easiest to say. And the meetings we had were so inspiring to draft the treaty for the IACC that it reminded me of the momentum for the International Criminal Court. And I think it might take a while, as Justice Wilson has said. You know, it's not going to be overnight. We've got to stay the course here. But I think in time, there will be, just as there was a momentum for the ICC, there will be a movement, I'm sure, more towards this IACC. So in short, I would encourage anyone here today, young people, and everyone, to get involved in the IACC in whatever way you can. And I'm sure Ian Lynch and Sarah Tishaw and others at the III can find lots of different roles and activities where you can not just help, but be really, really pivotal. And so, yeah, I encourage you to really join, and ultimately, of course, if you're interested in working for international courts and tribunals, then okay, that's another path altogether. And then there are various different types of expertises needed at these courts. It's not just lawyers. We always, you know, being a lawyer myself, I tend to think of lawyers, and we need lawyers and we need investigators, but we need a bunch of different types of people. We need linguists, we need analysts, all kinds of professions to make these courts run. And whatever your background and experience, I would encourage you to follow that path, because it's rewarding. You know, I think it's important, if you set yourself, you have a career, you have, it's important to be passionate about what you do. And so I would encourage all of you to do that.
Thank you, Helen. It's in Gulu, where I come from, is that The Hague is one of the famous city in Gulu, specifically because of the Dominic Ongwen's case that it handled for such a long time. Most communities, whether the locals, they're fully aware and they connect with the city in that regard. Rebecca, you work directly with young people with different civil society groups, mobilizing communities. Rebecca has also shared the contact on the group for anyone who is interested to connect later or join, get in touch in what she's doing. Do you have any comments adding on what we've had already?
I mean, it's hard to follow those two excellent interventions, but a couple thoughts. And first, I'll start maybe at the lofty philosophical level. When the Convention on the Rights of Persons with Disabilities was being negotiated, there was a rallying cry by stakeholders and affected communities: nothing about us without us. There is nothing definitionally that does not impact youth. Every aspect of global governance impacts you, and you will be the ones to take this forward. Therefore, your seat at the table is needed, and you should not wait your turn. Now, I know that can be hard, and I know there can seem like a lot of barriers to entry. And especially with situations like this or discussions like this, where it seems like perhaps a technical legal issue and, I have to knock on so many doors and get my invitation. No, you should not knock. You should try to open that door as persuasively and with as much force behind it as you can. And that's why I'm giving you my direct contact information. You could also look at my organization. And I really hope that the III folks will connect you directly to specific mechanisms of mobilization around an international anti-corruption court. So that's the big picture. And then Ms. Brady did steal my line a little bit, that if you want to work in the cause of international justice, you don't just need to be a lawyer. With various, and so, I mean, I worked as a visiting professional as a lawyer at the ICC, and my colleagues were everything from linguists to psychologists, accountants in some instances. And because I hope we have a geographically diverse array of folks who are with us now and who will watch this later online, really encourage you to look at these schemes with the current ICJ and ICC, and of course within IACC down the line, as we need more folks from more diverse backgrounds joining up. And the last thing that I'll say is, I mean, it's a great honor and privilege to be among these esteemed eminences speaking about areas of international law. But when it comes to what's going to motivate your generations, and I say generations plural, I don't know who's Gen Z and Gen X, et cetera, in the call, that's for you to tell us, and that's for you to take forward. And I really hope that you have the initiative and the volition, and that you see the problems in your own community, in your own life, and in the world that you feel inspired to solve. And I know I'm learning all the time from the younger people in my network, networks, plural, I guess, and finding new ways to communicate and new mechanisms to engage with different communities. So I look to you for the answers. I know maybe you came here to hear us give some answers, but I'll turn the tables a little bit. And thank you so much for being a part of this conversation.
Thank you, Rebecca. The question is, what role can the UN Summit of the future play to advance the role of international tribunals?
I could take that question. So for those who are unaware, the UN Summit of the Future was called by Secretary General Guterres, and it's upcoming this September 2024, and seeks to really reset the global governance schematic, and has several goals that are organized: peace and security, environment, even tech, and some cross-cutting themes. Along the way to the Summit of the Future, just upcoming in a couple months in Nairobi, is a civil society summit. And this will be where an interim People's Pact is finalized into a People's Pact for the future. This accompanies a pact for the future that is in zero draft form. That's a technical terminology. Sorry, it's not that elegant. Issued by states. And heretofore, judicial institutions, in my humble opinion, I'm speaking in a personal capacity, perhaps on behalf of my organization a little bit, because we have made a statement to this effect, has been a little bit neglected. So organizations like mine, and with a ragtag pack of other civil society organizations, are seeking to have greater support for current judicial institutions, as well as support for new institutions in the People's Pact and ultimately in the Pact for the Future. However, it's not a zero-sum game about getting terminology. Well, that's hard enough, getting terminology into a consensus-based document. Implementation moving forward from September is going to be critical. It's going to see whether or not this whole premise succeeds or fails. And so with other organizations like the Legal Pact for the Future, like the World Federalist Movement, Institute for Global Policy, we are trying very hard to ensure that a strong judicial rule of law element is injected throughout these conversations, throughout the process, and throughout the outcome documents.
Thank you very much for all of you joining the session. From my side, corruption is something that affects everyone. You know, me growing up in Uganda, a personal story I could share. In 2010, my dad retired from civil service, and he's been chasing his pension for 7-8 years after he retired. In 2018, he passed away from cancer, and I remember in his burial, we received a call from someone within the civil service that wanted 20% of his pension. Of course, the family was desperate for money at that time, and we had to, you know, sacrifice 20% of the pension. And up to now, we never met the person. We just received a call, and his pension was processed, and it was paid by installment, but part of his money was taken away. So for me, establishing an anti-corruption court will not only help, you know, bring justice to people within local communities, but it will also sort of put responsibilities on people who, what I call broad day robbery that happening. Forget about the roads, hospitals, forget about, but these are personal stories of, you know, of people who have had unworked money, they've worked all their life, and you know, people coming to take it away. Thank you very much, and thank you Integrity Initiative for giving me this privilege to have a conversation with this remarkable group of experts within the legal field. Thank you very much. It has been exciting hearing from all of you, learning from all of you, and asking questions to all of you. Over to you, Maela.
Thank you, Robert. Thank you, Justice Wilson, Justice Hrdličková, who's not here with us, Helen, Brady, Rebecca Shute. Absolutely valuable insight you shared with us today, and your expertise has definitely shed light on the existing international courts and the potential impact of the International Anti-Corruption Court, which reinforced the importance of staying committed to the fight against corruption, as well as accountability and transparency on a global scale. And I echo all of your sentiments that corruption is something that we are affected not only on a national, international level, but communal, individual level. And we have this responsibility. We owe it to ourselves, to our families, to our communities to participate at any level possible and voice that opinion. I would like to also welcome you to mark your calendars for our third IACC Youth Talk on March 27, same time at 9 a.m. Eastern Time. In the next IACC Youth Talk, we will delve into the treaty drafting process of the International Anti-Corruption Court, highlighting various subcommittees and key aspects of the draft treaty. Expert speakers will explore topics such as asset freezing, jurisdiction, internal court management, international cooperation, and perhaps we may also discuss some potential case studies, perhaps from Nigeria and Guatemala. So hope to see you in March, and please be on a lookout for a forthcoming email with more details about our next event. And thanks again to all our audience for being here with us today. Thanks again, our esteemed panelists and Robert for gracefully engaging us in this very informative discussion.